Hi, everyone, and welcome to Legal Diagnosis, the podcast where law meets healthcare. I'm Liz Sullivan, the chair of the healthcare practice group at McDonald Hopkins, and we are very excited to bring this discussion to you today. McDonald Hopkins has been serving the healthcare provider community across the healthcare continuum for more than 50 and also welcome back two very knowledgeable and experienced healthcare attorneys in our healthcare practice group, and that is Rick Hindmand and Rachel Carey. On the podcast today, Rachel and Rick are going to talk about remote patient monitoring and related compliance considerations. And with that, I'd like to turn it over to Rick and Rachel.
Thanks, Liz. As Liz mentioned, we're going to be talking about remote patient monitoring, and remote patient monitoring, as some of you may know, has been rapidly expanding in recent years, and it's also drawn some attention from regulators as well. I'm Rick Hindman. I'm a healthcare attorney in the Chicago office of McDonald Hopkins, and I've been involved in helping healthcare providers as well as companies that assist healthcare providers in furnishing remote patient monitoring. And I'm here with my colleague Rachel Carey.
Hi, everyone. My name is Rachel Carey, and I am a healthcare attorney that's tied to our Cleveland office, but I work remotely in Virginia, but serve clients all across the nation, really. And I have helped some startups in the RPM, RTM space, and also work with practitioners, primarily in more of the rural areas that are trying to assist some of their patients that are a little bit harder to get in the office and see regularly. And I think with some of the changes coming up, we're going to just get continued questions about this. And as we get into it, you'll see, there's plenty of things to be on the lookout. And we're happy to be here to give you sort of some ideas on how to go about navigating those issues.
Thanks, Rachel. And I think what we're going to do, we can provide just a little bit of background on remote patient monitoring. And that there are various categories of remote patient monitoring in terms of how the services are provided and how they're billed for through Medicare and other healthcare payers. We're going to be discussing, we're going to really be focusing on two categories of remote patient monitoring. There's remote physiological monitoring, or RPM, which involves a collection of patient physiologic data, things like temperature, pulmonary function, blood pressure, using digitally connected medical device. Like they can be sensors, they can be pulse oximeters, they can home blood pressure monitors, and there are other types as well. And so healthcare providers like physicians and nurse practitioners and physician assistants, use these to help develop and manage a treatment plan for patients' chronic or acute conditions. So that's RPM. And a second type of monitoring, which is similar, also uses medical devices, is referred to as remote therapeutic monitoring, or RTM, which involves the monitoring of other conditions, and typically it's for category for conditions such as musculoskeletal or respiratory system status, or cognitive behavioral therapy. Cognitive behavioral health and therapy. And so I'll also mention there are other categories. So, for example, there's external electrocardiograph, ECG, cardiovascular monitoring, which can be done over other periods of time, like 2 to 7 days, 7 to 15 days, and some similar considerations apply to those as well. But we're really going to be focusing today on RPM and RTM.
Right. And one other sort of distinction to make between RPM and RTM and the uniqueness of each area is RPM, you really have to rely on the device to collect the data. In RTM, it is possible to have the patient put in qualitative data if they're doing more in the cognitive space. So just some things to consider in terms of how you're actually deploying the devices and things that they have to deal with in order to get information they need to bill. So with that, I'll turn back to you, Rick, to continue.
Yeah, thanks, Rachel. And as Rachel mentioned, there are some distinctions between RPM and RTM, but they also have a lot of similarities. So from a billing standpoint, there are really three different types of codes that are used for both RPM and RTM. There's a code that's used, a one-time code that can be used for initial setup and education. That 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 provides a relatively nominal amount of payment, but it can be used. And then there are two sets of monthly codes. There's a code that can be used for supplying the medical device and transmitting the data. And currently in order to get paid, you have to have typically at least 16 days a month where those recordings are provided. And there's also a set of codes that can be used for monthly treatment management, where there's actually someone looking at the readings, and there has to be at least 20 minutes a month that are spent in order to bill those. So physicians and other providers can get billed under these codes, and two of the sets of codes they can bill monthly. And as Rachel mentioned, there are some differences. We talked about the types of conditions, and then also different types of practitioners can bill and supervise these services. So, for example, if it's RPM, it's a physician, or typically a physician, nurse practitioner, or a physician assistant. For RTM, it's really a broader category of professionals that can bill for these. It can be the same types of providers, physicians, NPs, PAs, but it can also be therapists such as occupational therapy, physical therapists, speech language pathologists, clinical social workers, psychologists, other categories. Yeah, and that's a difference. And as I think Rachel mentioned, like with the RPM, the device has to automatically upload data and be capable of actually transmitting the recording. Another difference too is that RTM services, most of those codes are designated health services, so they're covered by the Stark Law, which relates to physician referral. So you might need to be a little bit where you kind of cognizant of that when you're cognizant of that when you're structuring relationships. And I'll also mention that currently you can't bill RPM and RTM at the same time in the same month for the same patient. There are a number of other similar codes, like for care management, you sometimes can't. And I'll also mention too that there are proposed changes that CMS has proposed, which would really expand the ability to provide RPM and RTM, and these changes would allow billing under the supply codes, even if there's fewer than 16 days. So, for example, it could be 2 to 15 days. Currently, it has to be 16 days in a 30-day period. Also, additional codes would allow for billing of the uh, treatment management codes, even if there's less time, like even if there's only 10 minutes instead of 20 minutes in a month. So what we'll need to do is wait and see what ends up coming out in the final Medicare physician fee schedule.
Right. And there's also sort of commentary and requests for feedback surrounding some of the supervision that's required for these codes as well. And I'm sure there was plenty of comments put in there because that's certainly a big part of the models that a lot of these providers you consider when taking on either RPM or RTM, is if they're able to use a lot of the work of some of those advanced practitioners or medical assistants and things to sort of do some of the labor of getting the data together and getting it to the practitioner that can actually bill to review and review and bill. Um, some of the other certain types of settings as well as being considered for continued flexibility for certain direct supervision and able to be doing it more on a real-time audio visual setting, particularly with RH, rural health clinics and federal qualified health clinics, the rule is proposing to extend flexibilities for virtual direct supervision, um, at least through 2026. And I think that we'll probably continue to see questions and pushes for that direct supervision flexibilities continue for other settings as well.
Yeah, and as Rachel indicated, these are the kind of the standards for remote patient monitoring are really evolving, and so we're probably going to have more kind of coming up in the next month or so when the final things to keep in mind too for remote patient monitoring is it's common to have essentially collaboration structures where physician practices can provide all the services themselves. They can provide the device, they can provide the staff if they have it. Now, very often it's fairly common, very common, I think, for physician practices and other healthcare providers to contract with an outside company to come in and help provide those services. And the company can provide various types of involvement. They can provide the medical device itself. They can provide the HIT platform that's used. They sometimes provide staff members who can monitor the data from the medical device and communicate with patients, which, by the way, is supposed to be under the supervision of the billing practitioner. So you've got collaborative business models out there, and it's important to keep in mind the person who bills for it, which is typically a physician or PA, or it could be other types of professionals or a nurse practitioner, it could be other types of professionals, are ultimately responsible for it, even if they're contracting with an outside company.
Right. And we get a lot of questions surrounding required supervision. And another thing that you have to remember is to consider your state laws and what those people that are supporting you are actually allowed to do. I think especially when it comes to any of the like cognitive behavioral therapy and things like that, what they're you know, when you set up these procedures and things, when does it become like they're actually making a determination based on data to refer or run it up the chain? Like when are they making a decision versus like when are they just collecting and sending it on? So those are, very important distinctions to look at specifically for your own state to see what each level of your team is allowed to do. And I would just say, don't ever rely on a vendor or an outside company to tell you exactly what the law requires. Because again, as Rick said, ultimately the billing provider is who's responsible.
Yeah, that's a good point. I think there's a tendency sometimes for people to think, okay, they're like the physician thinks, okay, we're contracting this out. I don't need to do anything, and that's not really true. And medical necessity applies as well. You need to be able to have something in the records to support it. One thing I want to mention briefly is that there has been some regulatory agencies and within CMS and elsewhere are kind of trying to figure out, I think they're kind of trying to figure out how to address remote patient monitoring and figuring out exactly how it's being used. Just in the last 14 months or so, the Office of Inspector General has issued several reports uh, uh, calling for expanded su for kind of expanded scrutiny of remote patient monitoring. So very often when that type of thing happens, there could be more audits coming down, and so there is some concern on the regulatory standpoint. So I'm not going to get into that in detail, but I will mention we have some blog posts that we published, and you can access through the website, or if you want to contact either Rachel or me, we can provide more information on those as well.
Right. And just from our sort of working in the area, I can tell you, this area's had rapid growth. That's one of the reasons it's on regulators' radar is, whenever they see a big spike in codes, they're like, what's going on and enrollment for this sort of thing. And they're not always, when there's like a big push in by new providers, or there's, people are just sort of quickly adopting a new service line or things like that, they're not always vetted as well as they should be. I can tell you personally, having had a number of providers come to me with proposed contracts. Some of the early ones I saw were a lot of just taking a percentage of collections, which we know always sort of rings, warning with all of any healthcare attorney. You know, why are they doing that? Is there any reason that they can't, is there any possibility that they actually can do it that way and actually be compliant with anti-kickback statutes and things like that? So when you see stuff like that, it certainly gives you pause and, understand why it's on OIG's radar and just realize you need to look out for those sorts of things.
Yeah, that's a good point. And there's several of the types of kind of structures you see quite a bit, or sometimes providers, the outside company, the vendor, maybe maybe paid on, let's say, an hourly basis of what the time that's actually spent, and sometimes it's on more of a per service basis. So for providing a given service, it's going to be X dollars a month or something along that line. There are ways you can structure it without getting into percentages that may actually get you to fairly close to the same place. And I
Right.
guess one of the we do want to talk about, and I'm sorry, I didn't mean to interrupt, but we do want to talk about some kind of compliance issues that come up. And um, um, one thing to keep in mind is it's important to be able to to be able to document that you're complying with all the billing requirements. So there are, in order to build the codes. There are a number of requirements that have to be satisfied, and you have to keep in mind the medical necessity requirement. That there really has to be some kind of purpose for doing this. It has to be done in order to diagnose or treat injury or somehow improve function. And also there's a patient consent. And again, I'm not going to do detail on this, but there's a requirement of getting patient consent, and there are supervision requirements, especially since a lot of these services are done on an incident to basis that requires the billing practitioner to be supervising. There's also an interactive communication requirement, and the time requirements are important to be able to have some system in place where you can document the fact that the 20 minutes are provided, because if you don't provide at least 20 minutes, you can't bill for the treatment management code. And the rules there are pretty strict. You can't round up. It has to be actually 20 minutes. And of course, depending on what changes are made, there may be the possibility of fewer than 20 minutes, but it'll be important to see that. And also there's the supply codes being there, collecting 16 days of data. So the place where that may come up is if there's ever an audit. Um, yeah, the auditor may come in and want to look at the records, and so it's important to have documentation.
Right. So definitely audit readiness is something to think about at all times. I think, if you're a vendor trying to get into this space, or if you are a provider looking at vendors, definitely seeing what the capabilities are for pulling audit trails pretty quickly. That's something that I would suggest. And any sort of vendor that can pull consents really quickly, because that is also one of the areas that OIG has indicated as been an area of noncompliance. And the other thing I would mention that I don't think we've touched on yet, is if the devices are FDA cleared, also making sure that's also a requirement of being able to bill for these. So I would make sure that you have that documentation pretty quickly. Um, any final thoughts from you, Rick, on sort of like audit readiness and things that people really need to look out for when deciding to get into this field?
It's important to keep in mind that there are a lot of issues to think about here in terms of kind of complying with the billing requirements and also other applicable requirements. And one thing to keep in mind is a copay requirement. So these services typically, at least for Medicare, require a copay, and so if the copay is typically not if the provider doesn't even try to collect the copay, it could be viewed as as some kind of a patient inducement, create some fraud and abuse issues. You also have issues, particularly when when there's a vendor involved, someone who's not the provider. You've got the contractual arrangements. So you need to watch the way that those are structured, who has what responsibilities. The contract's important. We don't really have time to get into detail here, but you can certainly, if anybody has any questions, you can contact Rachel or me.